The statute of limitations in slip and fall cases. If you wish to file a lawsuit after a slip and fall, you will need to be aware of the time limit that every state puts on this type of lawsuit. If you had a slip and fall and were subsequently injured, you may wish to take your case to a civil court so you can receive a monetary award for your damages. However, taking a case to court is never as simple as it seems, especially when cases involve the statute of limitations. The statute of limitations is a law set by the state that gives every claimant a deadline for filing their lawsuit. Regardless of how you fell, what caused you to slip, or the injuries that you sustained, you will need to be aware of your state's statute of limitations. Each state is likely to have its own statute of limitations, so you should check how your case will be affected in your state. Some statute of limitations can be as long as 10 to 20 years, whereas others may last just 1 month. If you fail to file your lawsuit on time. If you fail to file your lawsuit on time, the court may dismiss your claim. If you file a lawsuit after the statute of limitations has expired, you may be expected to pay the defendant's court costs. This is just one of the reasons why it is so important that you're aware of how long you have to claim. Slip and fall cases and the statute of limitations. The statute of limitations clock in a slip and fall lawsuit usually starts on the day of your injury. If, for example, you live in a state where the statute of limitations gives you 1 year to file your case, you will have 1 year from the date of the accident. In this time, you will have to decide who you think should be held liable for your accident. Extending the statute of limitations. Many parts of the United States will allow the statute of limitations to be extended, but only in a few circumstances. These circumstances include, but are not limited to, if the plaintiff, the injured person, was mentally ill. If the plaintiff was a child at the time of the slip and fall. If the plaintiff suffered from a mental disability for a length of time after the accident. If the defendant had left the state after they were negligent. In cases where a minor was injured in a slip and fall case, the statute of limitations may begin once the child has turned 18 years of age. If your state offers a 2-year statute of limitation, the 18-year-old will have until they are 20 to file a lawsuit. The exception to the rule. There is a rule that is occasionally used as an exception to the statute of limitations. This rule is known as the discovery rule and is often used when the injured person was unaware of their injury right away, or when the defendant's actions are likely to have caused the plaintiff's injury. In cases such as these, the statute of limitations does not begin until the date when the injured person had notice or knew that they were injured, and had notice or knew the cause of their injury. For example, if you had slipped on and subsequently fell over a loose floor tile, you may not have thought you sustained any injury. However, 4 years later you start to suffer from shoulder pain. You visit your doctor and you are told that one of your shoulders is slightly fractured, and you have developed arthritis in it. The doctor informs you that your injury is approximately 4 years old and that it is as a result of a fall. In a situation such as this, the statute of limitations may start running from the day you discovered that you were injured as a result of the accident that you have 4 years previously. This means that, depending on the state that you live in, you may have 1 to 3 years to file a lawsuit against the owner of the property that you fell in. Please see Proving Who is to Blame for Your Slip and Fall for more information about who you could hold liable for your injuries. If you have been injured in a slip and fall accident, speak to a personal injury lawyer as soon as you can, as the clock will have already started ticking on the statute of limitations.